Good morning, everyone. This is 𝗯𝗲𝘀𝗁𝗃 from 𝗯𝗲𝘀𝗁𝗲. Thank you so much for joining our webinar today. We have with us today Mr. Advocate Denson Joseph. He is a well-known litigator who has an experience of spanning which spans for over 10 years. He practices in front of high courts, district courts, and various tribunals across India. Today he has joined us to share with us his own experience of how you can become the best litigator that there is. I will not take much of your time. I'll request uh, Joseph sir to take this session ahead. Thank you so much, sir, for joining us.
Thank you so much, Akshay, and good morning to all who have joined me right now. I will straight away, without wasting any time, as you said, there is a tremendous time constraint that you have been talking about ever since the idea has been floated across to me. I will straight away start off with the topic, but before I give, a broad insight into what is required to become a good litigator or to become the best among the litigators in India or globally speaking, I would just share a word about what litigation is all about. Now the point is there are today in the legal fraternity or when we talk about the opportunities that galore, for a law student, there are plenty of venues. But let me assure you something that there is nothing that can be compared to litigation. Now, having said so, I will straight away jump on to what are the skills that are required, and these are skills which I call indispensable skills, which are required to become a good litigator. So, of course, the first thing is, most important thing is drafting, right? So you need to be very well conversant with your drafting skills. You need to know how to put across your pleadings, how to actually present your case in the written format. Now, so either you get a good training while you are in your academics, while you're pursuing your 3 year or 5 year LLB, or you need to take up additional courses. I believe even 𝗯𝗲𝘀𝗁𝗃 is conducting courses on drafting skills. So probably a course like what 𝗯𝗲𝘀𝗁𝗃 conducts, or any other, any other platform which offers, wherever you get to learn drafting skills from. But then you need to be ready to, adapt or learn what you pick up from these various platforms or courses that are available easily online and offline as well. The second most important thing, of course, is the communication skill, without which you cannot make into the world of litigation. So, if you want to be a good litigator, of course, the most important, I would say, is your communication skills. And when I say communication skills, there are a lot of aspects. Of course, it is about how you convey your message to your audience. That is very important. How clearly you are able to convey what you want is very important as far as communication skills is concerned. And you will not be able to improvise upon it unless you are a very good listener, right? So when I say the third most indispensable skill, according to me, to become a good litigator, would be to work on your listening skills. Often, we as advocates, we are always in that aura that we know everything. And so when a client is talking to me, we normally assume a lot of things that, okay, this is how it is, this is how it is. I don't need to be explained a particular aspect of the issue that has come to me or that the client has brought to me. So it is very important to listen very carefully to whatever your client has to offer or whatever your client has to say, because unless you are a good listener, you won't be able to do justice, to his case, or even present yourself appropriately in the before the right forum. The fourth most important, one of the most important skills, which needs a tremendous amount of work, is your cross-examination skill. Since this topic is largely to give you a broad idea of what all you need to look into to become a good litigator, I'm not actually going to delve much into the in-depth analysis of what a cross-examination would be, how it is to be dealt with, how you have to train yourself, or what are the cross-examination techniques. There are lots of information and knowledge as well as help books available, available out there. But then the point is, this is one of the most essential skills, another important skill that makes you a good litigator. So you actually, it is a common thing. You would have heard many litigators or many advocates actually propagate the fact that cases are made or destroyed, during a cross examination. So the cases can be made or marred, at the time of cross examination, and for that you need to be very proficient in your cross examination skills. And last but not the least, the most important skill that I believe, is very important is your closing technique. So, so you need to learn various and varied options of how to close your case or how to close your arguments within the court. Just to summarize what I have spoken about now, as far as the indispensable skills are concerned, they are. I spoke about drafting, I spoke about communication, I spoke about listening, I spoke about cross-examination, and the last but not the least, your closing skills. That is very important. So having spoken about the indispensable skills, now let us talk about what is the kind of conditioning that is required, right? It is very important to also understand, it is just not that you come out of your LLB course 5-year or 3-year and then suddenly you are ready, litigation ready. It is not. To even become litigation ready, I would say at least you need to put in about 3 to 5 years of rigorous hard work before you can really confidently stand out before that court and actually, present a case confidently and, get the desired results which your client expects of you. Having said that, what is the kind of conditioning that is required? Let me, in this section, what I'm going to talk about is I'm trying to take you inside the mind of a litigator or inside the psyche of a litigator. Now, many litigators often don't confess this, but the fact is, most of them, I would say most of them, they might be seasoned. I mean, I leave out the seasoned ones, but most of the litigators out there have the problem of anxiety. Whenever you are actually getting out of your chamber and walking towards the court, they start developing these, I won't say it's an anxiety disorder, but they have these signs of anxiety. They might show, they might not show, but they might be very anxious within themselves, within their body or within their mind. So that is one of the most rampant, I would say, disorders, but the least spoken of. So first of all, the conditioning, the most important thing when I talk about conditioning is that you need to really, work on anxiety control. So how can you go about it? That I will speak about, probably down the line when I speak about how to train yourself to be a litigator, right? So the second most important thing is the rate of speech. Okay, now what is the rate of speech that I'm talking about? We Indians, as such, I mean, it is a general phenomena with all of us Indians that we speak at a much higher rate, which means the number of words that we deliver within a minute is quite high. I think we speak at a rate of about 120 to 150 words a minute or something around those lines. Whereas the apt, rate of speech would be about maybe 60 to 80 words per minute. That would be the ideal rate of speech. But we normally, and this rate keeps fluctuating. For example, if I'm speaking slowly here, maybe when I'm in the court, I'm actually hurrying up a lot. And there are various reasons why I'm doing that. But then one of the reasons could be anxiety. The other could be that I'm seeing that the judge, doesn't have much time, or he's not giving much time to the counsels to present their case. So I have to really hurry up and present my case in the shortest possible time, maybe in 2 or 3 minutes or so. And so the point is, you need to actually, work on the rate of speech. It is a very important aspect as far as, your your presentation within the court, or one of the essential skills or conditioning that is required to put you on the roadmap to becoming a successful litigator, right? Then the third is, of course, the body language. You need to actually practice a lot of, I mean, many of us, I would say being natural is the best, of course, but then there are lots of things which you need to learn in terms of body language. I emphasize on body language a lot. I tell my interns when they come to us for training that, okay, there is a particular way or a way that you should conduct yourself in the court. There is a particular way that you should actually, even while approaching the, approaching the court or walking away from the court, there is a particular demeanor that you should be adopting. See, now the topic here we are talking about is the best litigator. So if it doesn't, the word best doesn't appeal to you, then you can actually approach and leave the court in a way that you want, or completely being natural without any training, that is fine. But when we are talking about the best, then there are certain things that we need to watch out for. There are certain skills that we need to train ourselves in. There are certain, certain things that we need to observe. Essentially what I'm trying to say is, you need to condition yourself very well. It is not just the little knowledge that you've gathered from your academics, from your 3-year, 5-year courses, that is going to help you become the best litigator. It could help you become a litigator though, but then the point is, what we are talking about here is to become the best litigator. So then there is a tremendous amount of work, tremendous amount of care that you need to put into your conditioning. Now, the third important aspect that I would like to share with you, with all of you here is, or the would-be litigators is, what is the right approach, or what is the attitude you need to have to become a good litigator. So the first most important is you need to be very observant, highly observant. And when I say highly observant, what do I mean by that? What I mean by being observant is, where do you actually start? Where do you start your learning from? So once you have moved out of your college, normally what we do is we would join either a law firm, or we would join a litigator or a practicing advocate, right? So when we do that, what is important is, we normally spend the initial hours, initial days or years sometimes, unfortunately though, spending most of the time in drafting, or I call it copy pasting, and just changing the names and addresses, and probably creating a lot of drafts, and I call that as production work. Unfortunately, you spend very less hours where it matters the most, which is inside the courtroom. So what I suggest is, particularly those who have started on their own, or as independent practitioners, this is my key success, key to success, and that is, visit the courts more. Whether you have work or not, it doesn't matter. Visit the courts and try to understand what is the environment, what is the the ambience there, what is the how does the overall environment evolve around the cases on a day-to-day basis. How does a judge deal with the advocates? How do the advocates present their cases? How do the 𝗹𝗄𝘃 or the reader deal with the people who are approaching him, or the advocates who are approaching him, or the munshis who are approaching him, and the court crafts, so all of these need to be. So what is when I talk about the right approach, what I'm trying to tell you is, even once you are, you have 2 to 3 years or even 5 years of experience, this is a very important skill, or a very important approach that you need to have. For example, I do it very often. If I've taken up a matter and it is to, let's say, be presented before a particular court, I do try to visit that court a day or two prior and actually understand how the judge reacts to various forms of presentation by different advocates, right? So you can see, when you're in the court, you would be able to see very junior lawyers coming and, or even paralegals or interns coming and seeking adjournments. So right from that word, I'm just trying to tell you the very basics. So right from those aspects, that how does a judge react to a particular statement made to him, So, and then how does a judge react to arguments? What is his demeanor? What is his conduct? What is his general body language? What is his, does he look approachable, or does he, does he look very conservative kind of, does he have a very conservative approach or something? So all of these, aspects are to be observed, and that helps me actually plan my strategy of how to present my case before that particular judge, or in that particular court. So it is very important to actually, uh, visit that court uh, uh, prior to presenting your own case. When you are particularly out of college, you're certainly not presenting cases, but then for you, I would say you need to spend more time in the courts rather than spending times within the offices, or doing the back office work. But of course, yes, back office work is important, because that is where you actually pick up those drafting skills that I had spoken of very, right in the beginning. Now, having said that, when I'm saying you have to observe, you also have to observe, because what we are talking about is here is being the best litigator. Then what you also have to observe, or where you have to, lock your focus, is how the lawyers or advocates who are coming to conduct their cases are presenting their cases. How do they, for example, how do they open up, or how do they, first of all, how do they approach the court? Then how do they actually open up? How do they introduce their case? How do they build up their case or build up their arguments? So what I'm talking about is about the delivery part. So how do they deliver their arguments, and what is the demeanor, with which they approach the court? How do they conclude their or close their arguments? All of these matter a lot. Nothing works, nothing works as ideally as we learn theoretically. It is very different when it comes to the practical considerations, or how your cases are dealt with in the court. So I leave that up to your personal experience, how so that you see and learn from it. But what I'm generally telling you is that you need to be observant as far as the demeanor is concerned, as far as the delivery is concerned. These are two key areas that you need to pick up from your seniors. So having said that, then what the second approach that you need to have, I spoke briefly about it, that you need to be understanding. So when I say understanding, I'm not really talking about the emotional part, but what I'm talking about is you need to spend time diligently trying to understand what your client actually wants. So when a client comes to you, he might come and be talking the world out to you. He might talk things from A to Z. But then the point is, you need to really understand very clearly. You need to listen to him, of course, first. Listen to him very patiently, and then understand clearly that, okay, what is it that he wants? Jot it down very clearly. So unless you write down, I'm assuring you that you won't be able to really, reach the point or understand the remedy very clearly, that what exactly is it that my client wants. So having said so, understanding your client is of paramount importance. So the second approach that I'm talking about is, after the observation thing, is that you need to be ready to understand the needs of your client. That is very important. And third, then once you have understood the the needs of your client, you necessarily don't need to opine then and there. That is one of the biggest mistakes that many of the advocates, my friends in my legal fraternity do. They are eager to jump on and come out and give some opinion or the other. What I would say is, this is the only profession where before your name there is a word that is prefixed to your name, and that is learned. Even when you're being addressed in the courts by the judge in his order that is dictating, or the order that is pronounced, it is always written learned counsel so and so, right? So what I'm trying to tell you here is, before giving an opinion on a particular matter, please take your time, please do your research. Please tell your client that I will come back to you. Let me understand all the facts that you have given me. Let me just analyze it a bit, and then I'll come back to you with the best advice that can be offered. So I call that a learned opinion. So let us come back to our clients with learned opinion. That is very important, so that we don't come out and give out any opinion that comes out within the short limited experience that we might be having. So it is always preferred to come out with a learned opinion, and that takes a little bit of research, quite some drill, and a little work that you need to do at the back end. So having said so, so when we are also talking about research, then we are talking about the third aspect is research. So to make that opinion, you need to do some research based on the aspects or the outline of the facts that your client has given you. What are the research domains that you would be researching? So I would say the two immediate domains that come to my mind is one is the possibilities, and second is the the precedents. So if a client has come to you with a particular issue in hand, recently I have filed a writ in the Chandigarh High Court, and that pertains to school fee, for example. Now, when I'm talking about a school fee, you will find a number of writ petitions which have been filed and either dismissed or they are pending or something like that. So the point is, when it came to me, when the clients approached me, I told them very categorically that, see, you leave the file with me. There is a bunch of papers. I will study the matter. I'll study what has gone wrong with the other petitions, and then I'll come back with something which is really meaningful and which will make a difference. I don't want to file a writ petition just because somebody is giving me business. No, I don't mean to do that. That is not the kind of work, at least I as a person, intend to do, or a good litigator or a good advocate will do. So the point is, I researched the subject truly for almost, I would say, more than 45 days or so. I mean, it is too large a period, humongous a period to research a subject, but I did that, and really came down to remarkable revelations, I would say. And then I really drafted my petition, and now I filed it before the Honorable High Court of Punjab in Chandigarh. But so what I'm trying to say is, it is very important to have an in-depth analysis of where exactly you stand, what exactly the subject is, and then go back and do some research so that you come back with an learned opinion. The fourth thing that is important is, once you have made up your mind, once you are ready with your opinion, once you are ready with your outline draft, I call it a pre-final draft of your petition, you need to have a caucus with your prospective client, or the client who has actually approached you, and you need to discuss that pre-final draft so that you could actually really understand whether all the issues that he has, I would say it is a relook at the the facts which were presented to you, but this time you are having a relook together with the client. The client is being taken into the process, which normally many advocates actually avoid. But a good litigator or a good advocate would never do that. He would always take the client into confidence, have a pre-final caucus with him, and then finally finalize the draft, and then go ahead with the final final drafting of the petition, and then the final the filing of the petition as such. So then we talk about the next most important aspect as far as the approach is concerned. I think another important thing would be to after this pre-final caucus, you need to be actually very prepare very diligently as far as the other aspects are concerned. So you have taken care of the drafting, you have taken care of the caucus, you have actually jotted down everything very well. Then comes the out of court thing, which is out of chamber thing, which is the filing part. And then you need to also, at this stage itself, you need to be very good with your summarizing. That is very important. So and another important thing is summarizing yourself. So you might have prepared a draft of, let's say, 60 pages. What is important for you is the synopsis of the entire case, which should not be more than at the most more than four size pages. or sheets. So, but I tell my clients that this is how we prepare. So when the key word is summarizing when I talk about the approach. When I'm standing before the court as a litigator, the I within the first 4 or 5 lines, you should be able to convey the case to the judge. If you have done that effectively, if you have done that, uh, uh, you know, sacrosanctly, then in that case, the judge would actually understand, this is the case, and I immediately issue a notice of motion, or the next, the next process. So the point is, it is very important for you to learn to the word that we use legally is brevity, right? But then I would say learning to summarize your presentation is very important. So you need to have this approach of presenting it in a very brief, very succinct manner, where in the first 4 or 5 lines, the court would understand very precisely exactly what is it that you are actually asking for. If you're successful in doing that, you have your case with you. Nothing can stop you, or nothing can come in between your success or getting the remedy that you're aiming at. um, uh, the least visited approach, which I would say is the sixth approach, is be courageous and be ready to innovate. So the word is innovate, but to innovate, you need to be courageous. You cannot innovate anything until you're courageous, particularly in the courts. Because first of all, as I said, it is a tough job standing in the court and presenting your case. Particularly for, I'm talking in the perspective of the beginners. I'm not talking about seasoned lawyers. I'm not talking about seasoned big names, huge names that you already keep hearing every now and then. But I'm not talking about the types of 𝗯𝗲𝘀𝗁𝗲𝗏, or I'm not talking about, very respected Rebecca John, or a number of 𝗹𝗶𝘁𝗶𝗴, name and any one of them. I'm talking about not the doyens, but the beginners. So how can you, as a beginner, master the craft, and probably shorten your journey, and reach the top at the earliest. So that is the aim of this entire session. Having said so, innovation is one thing that can actually put you on the fast track. So but however, innovation requires a lot of courage, because what happens normally when you begin, when you are a beginner, or when you started as an independent lawyer, is most of the times what I have observed is that people around us actually, push us into submission to say that no, this you cannot do this. It is only this that is accepted in the court, or within the legal fraternity. This approach is not acceptable. A case, if I'm to cite a case for that particular situation, as um, one of the famous cases that I am working on is the pothole death case. Now, this is about a child who was killed due to a pothole in Faridabad, which is where I reside. And the police had filed a closure report thrice in this matter, and we had to go to the High Court and get this case reopened. And just to share this experience, we were told throughout, when we were actually consulting, researching, we were actually conducting a lot of caucus with many legal experts. Some of them really, I would term them as legal doyens, and most of them would say, okay, in this matter, you could actually, at the best, you could get, is compensation. And some of them even said that there is no point of, proceeding in any other direction. So, but what we were intending, and what the father of the child, his name is Manoj, and what he intended to do was largely, he wanted a punishment for the contractor, or in this case the NHAI, where he wanted that the persons responsible for that pothole on that road should be punished, and they should be charged under a criminal offense, and they should be punished accordingly, and prosecuted and punished. So having said so, it was, with all the pressure that was built around us, it was very tough to stand up before, and that too not a trial court, but the Honorable High Court, and tell them that, see, what I am seeking is a criminal proceeding. It was really tough. We had to really innovate on the way that we would actually, put up this matter before the court, and actually convince the court into proceeding in the direction that we wanted to take. And thankfully enough, our innovation worked, our courage paid off, and the court actually issued orders which actually put the case onto the right track. And this is, I think, this is one of the landmark cases that we are working on. So the bottom line, what I'm trying to say is, one of the most I would say this is more towards when you have become a little more a little more mature and handling the other aspects that I've spoken about, that you can actually get on with this innovation part. But yes, you need to show some courage. I believe when we were learning the essential skills we have already spoken about, and we have even in our academics, in our 5-year 3-year LLB courses, we have always learned, or at least heard, that an advocate needs to be courageous to present his case appropriately and convincingly before any judge, for that matter. So innovation is one thing. Probably it is a new thing that I'm giving you, but then yes, it is a very essential aspect, essential approach, essential attitude that you need to develop, so that you can sway cases and give life to a case which seems to be completely dead and gone, dead and buried. So having spoken of these approaches, I have spoken about 6 approaches. Now, what are the mistakes that we often do? So just to add on to the approach, because the mistakes are a part of the approach or our attitude, and that's why I'm speaking about the mistakes that we often make as advocates, and which are the biggest roadblock or roadblocks that actually stop you from becoming the best litigator. So first of all, the most important mistake that the biggest mistake that we make is, taking things for granted. We often presume that, this is how a particular court will behave. This is how the procedures work. This is how, of course, there are certain procedures. There are certain procedures of how things are to be filed, how things are to be presented, how things, certain ways in which, the court functions and works. Certain ways in which most of us in our legal fraternity approach when it comes to drafting, filing, presentation of cases, etc. But when I talk about taking things for granted, I mean, let us not take things for granted. When I say let us not assume that a particular judge or a particular court would behave in a particular way, and on a particular day when you're entering the court, this is the only process that is going to happen. What I always advise against the norm to become a good litigator or a best litigator is, whenever you're stepping into the court, always be aware of the case that you're going to represent, or even going to mention before the court. You must have a fair knowledge. I won't say an intensive knowledge, an in-depth knowledge, but I would say if you're going to mention a case, you must have a fair knowledge of what this case is all about, right? But when I talk about litigation, I would say anytime that you're approaching the court, no matter what, no matter the stage of the case, you must know A to Z of the case. You must know you must know your case cover to cover. It is very important. The biggest mistake, as I was speaking about a while back, is that most of us in our fraternity just walk into the court think that today it is only a reply which is going to be filed by the respondent, not knowing that it might give me an opportunity that I might be able to bat for some other aspect of the case, which might catapult my case from where it is to where it ought to be, right? So having said that, it is very important not to take things lightly when you're approaching the court, and not to take procedures for granted. There might be an opportunity that would come your way, and you should be ready to knock it off at that particular when that opportunity comes your way, or when you see that or smell that opportunity. Second is, not ever be complacent. It is largely, I would say, an extension of what I said. Don't take things for granted. So don't be complacent. So just yesterday we were talking about, a colleague of mine, and we were just discussing it within our chamber. And they said that this guy used to be very good, but now he's, he's taking things for granted. He's not very serious about the cases that he takes. He doesn't take his clients seriously. He doesn't take even his colleagues very seriously. That is a bad remark for any advocate, for any advocate from within the people from his fraternity or from a client or from anybody for that matter. What is important is you should never be complacent, always be sure, always be, I would say, sincere at your work. Be very sincere in the in your approach when you're taking up a case, when you're dealing with a remedy that you need to offer to your client, when you are dealing with the even the back end. Once the client has left, you're left with what is left behind is you and the case, the facts of the case. That is where you need to exercise your utmost diligence. That is when you need to exercise your utmost sincerity. So you cannot be complacent. You cannot be complacent whether with your client or whether with your case or whether with your colleagues. So all the C's are important that I mentioned of right now, right? So you need to be always on your tips, doing diligent work, sincere in your approach. That is what I mean. So that mistake you need to avoid, and it is an avoidable mistake. Then never be. So if you never be a slave to procedures. As I said before, you need to follow certain procedures, which are when it comes to drafting, when it comes to a format, uh, which might have to be followed while drafting a particular case. You might have to follow a particular protocol when you're approaching the court. You might have to present your argument in a particular way, but that certainly doesn't mean that you should be a slave to the procedures or the traditional procedures that are there. You can go a way out and tread your own path. You should, and for that, as I said before, that is essential, particularly so if you're ready to innovate, and you cannot innovate, as I said before, unless you are courageous. So certainly, as I said, you should not ever be a slave to procedures, but yes, you need to observe the right procedures, but at the same time ready to chart your own course. That is very important if you want to be the best litigator. Now comes the other important and my favorite part, which includes training. So what are the kinds of training that I could actually adopt? So I spoke about the drafting when first and foremost is the drafting skill, of course. So because you cannot present anything unless you have drafted your case very well. Of course, there are arrangements where when it comes to law firms and all, there might be juniors who are drafting and the seniors who are approaching the dais and actually presenting the case. But normally, I'm just talking about beginner here. I'm limiting myself to independent practitioner who is aiming to become the best litigator, right? Or a good litigator for that matter. So in that case, first of all, it all starts with your drafting skills. You need to be good in your drafting skills. You need to ensure that nothing is left out, which is important for your case. And you need to know what you've drafted. I've seen mistakes like, senior counsel standing in the court and pleading something which is not even there in the draft. You're not allowed to. I mean, anything that you plead has to be born out of your records, right? If your records don't bear it, you cannot actually plead that particular matter. And the opposing counsel comes demolishing the case, saying that, sorry, my learned friend doesn't know, sorry, what the submissions of my learned friend are not born out of the record. So it can be demolished that easily. So therefore, you need to be very good in your drafting skills. If you need to, take help from outside, you do that. If you need to take professional help, do that. If you need to take some training or take some additional courses, as I think 𝗯𝗲𝘀𝗁 also offers, take those courses and optimize your drafting skills. That is what I will say. Second, do a lot of reading. I mean, I've heard lots of speakers, coaches, life coaches, some even law coaches, advising people no need to read newspapers. It is a myth. It is not necessary. But I would say read a lot so that you have a good understanding about the language. Do you know that the language of the court? I believe most of us know that the language of the High Court and the Supreme Court is English, right? So I would say that you need to read a lot to master this language. You must master. I won't say that you need to be the best, but yes, you need to be at least the average is what I would recommend, right? So read a lot. And when I say read, then what is it that I should be reading? Of course, since you are a law student or aiming or a legal practitioner or a lawyer or a litigator, certainly you need to read a lot from the three areas that I would recommend, which is one is try to read a lot of editorials, right? Second, you could read some literature that helps a lot in your presentation within the court. And third, of course, the most important are judgments, right? So these three areas you need to actually work upon. Many of us may not be doing it. I myself sometimes feel, guilty that, okay, I'm not reading enough. But then these are three areas that you need to really work on. So I'll just repeat that so that you don't miss it out. Ensure that you read a lot of newspaper editorials. You read some literature, so that you know how, sometimes it helps. The knowledge of literature helps in presenting your cases in a unique way or a different way in the court. And third, last but not the least, you need to actually, read a lot of judgments. So what is the good part about reading judgments is you would of course know what is the case content, how the case was dealt with by the court, and most important of all, what is the legal language that has been used by both the arguing counsels, the arguments that were given by both sides, and how the judge has come to a particular conclusion. What are his observations? So what is the ratio behind the judgment? What is the obiter dicta that went into it? All of that. Reading is a very important skill, it's a skill, but I would say it is a part of the training. So eventually, eventually after some time, after you have been constant with your reading, then you would actually see that it becomes imbibed in you. It becomes a part of you that there will be natural flow of words. Your grammar would improve, your diction would improve, your understanding of the language would improve. When I say reading, always sit with a dictionary. I mean, let me remind you that it is important to sit with a dictionary, so that there might be some words which come across which you're not aware of. So you can always look up your dictionary and see, what that particular word means and how it is used in a sentence. Those are very important aspects which you need to master. Then always remember that evolving and improvising is a constant and continuous process. Even I, in perspective of where I am, I believe that I still have a lot to evolve. I still have a lot to improvise, and this is a continuous process. And I'm keen to learn and keen to unlearn as well those things which I don't need, to put myself up on the pedestal. Then I come back to the conditioning. When I was talking about conditioning, I spoke about the word anxiety, right? Anxiety control. So I would include that in the training as well, that yes, you need to also learn or train yourself to control your anxiety, which is very important. And for that, probably some breathing exercises are very good. So you need to, probably in under somebody or watch some videos maybe on YouTube and get across or understand how those breathing skills work in your favor. Breathing skill is one. Two is, there is something called CBT. It is cognitive behavioral therapy. So you could actually approach a doctor if the problem is acute. You are shivering inside and you are, words are not coming out of you're feeling stifled when you're in the court trying to come out with an argument. You are not able to find the right words. You are completely lost. Your brain is frozen. If those things are happening, then you need to actually consult a doctor, and probably you need to take a CBT or a cognitive behavioral therapy. And in most acute cases, you are also prescribed some medications. Otherwise, normally, I would say breathing skills help a lot. Then the last but not the least, I would say, is rehearse a lot of storytelling. That is most important. So if you remember, I told you, you need to summarize your case. You need to be able to present your case in 4 or 5 lines. That is your opening of the case, right? So if you are able to summarize, if you are able to practice your storytelling, you need to be a good storyteller is what I normally tell people, that if you want to be a good litigator, the best litigator, practice a lot of storytelling. A good storyteller would actually be a very good litigator. But then with the practice of storytelling, what is also important is that you need to actually ensure that you also practice rehearsing your arguments. So storytelling is one aspect. That is I would say that is how you begin practicing delivering your case or arguments in the court. But then when a case is up before you and when you're actually approaching the court, it is not a story, but you should be able to present your case as if you are telling a story to the court. And secondly, and that has to be done very secondly, and that is why you need rehearsing. I do it myself. I do it many times when I am approaching the court, irrespective of what the procedure might prescribe that day. I always practice or rehearse my case, the main contents of my case, that if this situation arises, what is it that I'm going to say? If this situation arises, what is this I'm going to say? If it is a case that is being presented for the first time, it is up for an admission hearing for that matter, then how am I going to actually present or introduce my case to the court? So storytelling, and I have told you, is rehearsing your introduction or rehearsing your case presentation is very important. With that, I come to the last topic of today's session, which is myths. What are the myths that are prevalent in the legal fraternity, which probably people think are indispensable to become a good litigator or the best litigator for that matter? I would say the biggest myth is that you need to hail from a lawyer's family, right? I have demolished that myth myself, so forget about it. And you can do it as well. I'm very confident about it. The second important myth is that you need to be a very good orator, right? You need to have the best oratorial skills. I am sorry to tell you, that is a myth that probably many of my senior colleagues would have actually advised against, but let me demolish it today. There's nothing like that. You need to be the best orator to be the best litigator, but what you need to be is a good communicator. If you are a good communicator, irrespective of your oratorial skills or whether you are not an orator at all, if you're good with your communication and you're able to convey the idea succinctly and understandably well to the court, then there is nothing that can stop you from becoming the best litigator. I think with that, I will wrap up my session. I will probably ask Akshay to open this session up for any questions if some of our friends or listeners have any questions to ask.
Thank you so much, sir. So I'll be taking up some of the questions that we have in the chat box,
yeah,
and in the Q&A box as well.
Yeah.
So for one of the recurring question is that, do you need to be starting from a trial court to become a good litigator?
Absolutely yes. Absolutely yes.
How important is it to have a specialization in litigation? I think what he means is a specialization in certain area of litigation.
Okay. See, I'll give you the practical approach. When you come into the general practice, let me put it this way. As I said before, you will not be thrown out before into a court and probably be asked to litigate straight away. But then yes, if you say you want to specialize, it depends on your interest. Normally, you should be open. I would say the initial years, be open to different areas of practice, and then eventually because otherwise you will not be able to see the world out there. So you need to be open to various areas of practice, experiment a lot with it, and then see which is that area where you are the most comfortable in, and then decide on which area to specialize in. Of course, specialization, normally most litigators or most advocates choose an area to practice in eventually. So you could do that as well. Yes.
One of other very common questions. So, should you join a litigation firm, or should you start with chambers and some senior advocate? How should you start?
I would actually recommend very strongly to join a chamber, not a law firm. I mean, that is only if you want to become a good litigator, right? Otherwise, if it's any other area, if it's a corporate law or something, of course, by default, the answer would be join a law firm. But then if you want to be a good litigator, always join a chamber, because you get to learn A to Z of litigation right from where it matters. You would be exposed to a lot of client caucus. You would be exposed to a lot of drafting. You would be exposed to the expertise of your immediate senior, and that will help you a lot chart your course or put yourself on that road to success, to becoming a good litigator.
Right, right. So, one follow-up question I have in this regard. So, how important is it to have a good mentor at this point when you're just starting out? And how do you know that you have a good mentor, or do you, when to know that you need to find another mentor? How do we go about it?
See, one of the essential parameters is the client satisfaction. I mean, that is the least spoken of, but I would say when you are with a mentor or when you have joined a chamber, you will be able to see how is it that your senior or your boss is actually, dealing with a client, and what is the rate of or the rating of your client satisfaction that he enjoys among his clients. So if his clients are largely dissatisfied, and I mean, you would know it because you are right there in the chamber where it matters. And if you are seeing that there is a lot of rukus out there, clients are dissatisfied, the approach, even according to you, I mean, who is just a beginner, according to you, is not the right approach, as you see. It could be in terms of humane grounds that you're talking about. It could be in terms of the sincerity, because you would know about your senior after the client has left, and much more, after the client has left, what is his approach towards a case. If you see that he is insincere, and generally there is a client dissatisfaction, that means you are working with the wrong person. You need to look out for change in that case.
Right, right. Also, one question is there. So we focus so much on developing our English skills, while the trial courts they use the local language, mostly Hindi, if you go in the north. So
Correct.
how do you go about it? How do you function in both the languages in like.
See, there is no shortcut to that. You need to actually, I won't say master the language, but you need to have a reasonable understanding. I would, share my little experience that I had, with a funny experience with a judge, one of the courts that I was arguing, and it was a final argument. And the language of this particular court was Hindi, as Akshay has rightly put it. And I was doling out my arguments one after the other, in fluent English. And eventually, but then the point was, what I was also doing is that after every argument that I would make, in English, maybe after every 3 or 4 lines, I would summarize that, in Hindi, in plain Hindi. Eventually, the judge, remarked that my English is not as good as yours, but I have understood what you're trying to convey, right? So the point is, you need to be a good communicator, as I said. So communication is not just about words; it is also about how you present it to the court. It includes your demeanor, it includes your body language, and it includes your presentation skills. So maybe you are a little, you have a little backseat with a particular language, so the vernacular for that matter, but that really doesn't matter, as long as you can, even if your strong language is English, you can actually present your case in English, but at the same time do certain sum ups, your summations, wherever it matters, in Hindi. And then, yes, I would recommend even that you should also try to learn as much as possible about the language, uh, particularly operative in that court, because at the end of the day, it is what is most important is that the presiding officer must understand your case. The presiding officer must understand your side of the story, uh, you know absolutely correctly, and the court must understand what is it that you're able to convey. And if it is English, if it good, if it is Hindi, it is good. If it is Oriya, it is let it be. But then in that case, you need to be able to, as a lawyer, be able to convey in that particular language succinctly and clearly what this case is all about.
All right. So next question is on very practical level. So this is something most of the lawyers, especially who are starting, face that first they do not know how to charge their services, how to bill that. Second, at many instances, people don't pay. Right, especially if you are dealing with individuals and not organizations who are generous with fees and everything. So how do you go about it? How do you charge your service, and how do you ensure that there is a recovery?
Correct. It is true that without without petrol your car can't run. So it is. I agree with that. It is a major area of concern, and I've heard about this concern a lot from many of my learned friends and colleagues out there. But I think if you deliver good service, I mean, I think your focus needs to change, and you will be paid well. If you are able to deliver, you know, excellent service, the topic is becoming the best litigator, right? So then what it also means is you need to be able to deliver the best service in the segment. So if you're doing that, I'm telling you, nobody would like to keep you unpaid, or there is no client who would run away from you without paying you for your services. At least I, as an advocate, have never faced a situation where my client is not paying me. And in my case, mostly, and I believe in the case of most of the successful lawyers out there, we are paid in advance for our services. So having said so, what I would say is that yes, you need to focus on the quality of delivery that you're delivering for your client. And if you're doing that, then there is no stopping. No client will like to not pay you, and in fact they will be rather keen to pay you, and even sometimes pay you good. That is one aspect. Second thing I would say, that you need to be able to communicate with your client. People start working on all sorts of games and tricks. I would strictly um, uh, tell you that never ever do that to fleece money out of your clients. Don't adopt cheap tricks. Rather, I would advise that deal with your client, communicate with your client, convey the thing that, see, these are the things that I'm going to do. This requires money, and unless the money is paid into my account, I won't be able to offer this service. Or I have done this and this has cost me so much, and this my time and energy cost this much, and therefore whatever it is, your hourly rate, whatever you have planned, whatever you have worked out for yourself, without which you cannot proceed or work, you need to communicate that on a sincere note. And I believe sincerity works. I haven't seen, at least in my situation, or even in the case of my colleagues who are working with me, I haven't seen them going unpaid. It might get late, but certainly you will be paid if the services are good. However, if you are not giving what the client is actually looking out for, certainly you won't be paid, and or you might be paid, you might be underpaid or so. Or the client might avoid paying you completely. So those things would happen. But I think excellence is always paid, and therefore always aim for excellence.
Right, right. So earlier you answered that one must start with a trial court. So how much time is enough to learn in a trial court and then move to a high court? How does it work?
See, I would recommend very strongly, at least put in minimum of 2 years, minimum. And depends on what chamber you have joined. Uh, that is the minimum. If you have joined a very busy chamber, where the chamber that you have joined takes up a host of different cases belonging to different areas of work, then in that case certainly 2 years would suffice. Otherwise, I would say at least 3 years. In that case, if the work is less, then you have a certain exposure. For that, you have to slog in at least 3 years before you actually think about foraying into the corridors of the high court.
Right. So there was this one question about ethics and morality of a lawyer. So we often hear things like, in certain cases where a lawyer was representing someone who is not good in a public view, then the lawyer also had to face certain, consequences. So what can be a possible ethics we can use to follow in this profession?
Okay. See, I think you have to set aside your religion, your linguistic domain where you hail from, the region where you hail from, when you have actually joined this profession of, I don't call it a profession though, I call it a service, an area of service. So being an advocate is an area of service that you have joined. So whoever the client be who comes to you, you have to actually represent him in the court appropriately and adequately. Whether he has a good case or not is secondary, but the first important thing, if a client has approached you and he says that you need to represent me, you ought to represent him to the best of your abilities and capabilities, right? Now, the point is, there are instances where, there is the public going against the advocate because he's representing probably a rapist for that matter, or a murderer. So either it is your policy that you will not be representing a murderer or a rapist, or if you're actually representing them. For example, if I'm to speak about myself, I have taken up a cause that if once I see the brief, when a brief is sent to me and I see the brief and I believe within myself that yes, this man is actually guilty, actually I don't take up that case, particularly if it belongs to the two domains, which is murder and rape. However, if I believe from the facts put before me that yes, and you could call me judgmental for that matter, that yes, this man is guilty, and then so however, if I see that this man is not guilty, then I would certainly take up that case and I would defend him, to the core, and ensure at least within my capabilities that he is set free. So that is what it is. So what I'm trying to tell you is, we have to rise above all our religion, all our barriers, let me put it that way, whether it be religion, whether it be linguistic, whether it be regional, and and then just focus on completely representing our client with utmost sincerity, irrespective of what, whether there is a backslash from the public or from even your legal fraternity at times. Because what you have actually taken a pledge when you actually pledged in to become an advocate is that you will represent your client with utmost sincerity, and that is what you need to stick to, and that is what professional ethics for an advocate is all about.
All right, sir. I have one final question, and I'll take up one last question from one of the participant who is asking to allow him to talk. So my question is that you're not just a litigator, you also practice in domain of arbitration and mediation as well.
I do, yeah.
Right. So are these things, litigation, arbitration, mediation, all of them form a whole of a legal practice, or are these to be treated as separate domains? And how often do you use these tools? Is it something that you often, yeah?
Okay. I would say I discourage clients from getting into litigation. When the client comes to me for the first time, I say that, and that is the tagline which I always use with my nameplates or boards that I have, that come to the courts only when you have exhausted all other remedies, that are available to you otherwise. So the point is, I discourage people from, embracing or coming to or taking up litigation or litigating their cases, because litigations are actually torturous. They take a long time. They are not very, I would say, not very comfortable for the people, even the litigating parties for that matter. Of course, it is paying for me, but then the point is, it is not a good experience. Let me put it that way. For example, you would have heard about the Sister 𝗹𝗶𝘁𝗶𝗴 case, which was decided after 28 years of litigation, right? Nobody wants such prolonged litigation for their matters. That is where arbitration, comes in, and that is where mediation comes in, even negotiation for that matter. So all of those ADR techniques come in. So, I try to, send many of the people who approach me, many of the clients who approach me, to adopt arbitration instead of litigation, if it is workable that way, right? So normally it is only commercial disputes which can be driven the arbitration way, and when it is matrimonial disputes, we actually step in and even ourselves do a lot of mediation. I think I myself have done over 500 to 600 mediations myself. So having said so, what I'm trying to say is, it is always better to adopt. They are different domains. They do form part of the general term, which we could say legal remedy, right? But then, or the the judicial process. But however, what I would say is, what is much more convenient to a client would be, or a general public out there would be adopting an ADR technique, whether it be mediation or whether it be arbitration. I recommend arbitration and mediation over litigation, but they all, of course, they form the part of the judicial process. Yes.
All right. Moving on to next question. I'd request Manoj to please put up your question. I've allowed you to talk. He has been requesting from a long time.
Okay.
Please, Manoj. You have to unmute yourself.
Yeah. So am I audible?
You are,
Yeah.
Manoj. Yeah.
Yeah, I am audible. Yeah, thank you. Thank you, Mr. Denson Joseph, for a very nice presentation. And in fact, like that addressed all nitty-gritties. And in fact, the highly impressive part was that like you actually did the dissection of all those things, and that was really remarkable. And 𝗯𝗏𝗀𝗃 you presented. Well, I have a specific question related to the cases that you referred here. One was the pothole case, and another is the education-related matter. And I must congratulate you that you, as you said, that we should innovate one or the other thing, and you were able to take into the criminal justice system. That is. So now my question, I just wanted to apprise you related to a recent development in the education matter, that yesterday only in one of the matter, the Director Secondary Education in Haryana, he has informed the Honorable High Court that the fee regulatory mechanism does not exist in Haryana. And for this, already an affidavit stating to the effect that we have devised a mechanism, it was placed in Haryana in 2013. Now, I was just seeing the similarity in the cases, like for me, although I have just done LLB, but not a legal expert as you are, can such type of cases be dealt under the law of torts? Can such type of government irresponsible persons can be brought into the criminal proceedings where they have made a perjury, not with the court and to the public as well? So just your expert opinion on this and what you have to say.
See, this, Manoj, thank you very much for all the compliments. I think this is Dr. Manoj, right?
Yes.
Okay. So, Doctor, the thing is very simple, because this topic is largely about becoming the best litigator. So I'll just very briefly come to this. The issue that you have raised, it is largely, it largely belongs to the domain of contempt. Law of torts would not apply here in the first thing.
Okay.
Second thing, the court, however, I have seen the courts are largely lenient when it comes to dealing with government officers and government authorities. So we really have to be very, tactical about how we go about it, and we have dealt with them in the past. We can do that, so we can discuss, later on after this session how to go about it. Yeah.
Yeah. Thank you. Thank you, Akshay.
Yeah.
Thank you. So this brings us to the end of this webinar. So I'd like to end this up by thanking Denson Joseph sir for doing this webinar with us. I hope this was very, very useful for a lot of participants. This was useful for me as well. Thank you so much everyone for joining in. You can check out our courses at legal drafting, English communication, and various areas of litigation on our website. Please check them out. So thank you so much, sir. I'd like to conclude this session.
Thank you, Akshay. You have been very good, and we'll see as catch up.